Продовжуємо засідання.
We continue our session. Please invite the next candidate, Mr. Dmytro Valentynovych Movchan.
Задається питання щодо відповідності кандидата на
We are
посаду
considering the issue of compliance of the candidate for the position of the HAC judge, Mr. Dmytro Movchan, with part 4 of Article 8 of the law of Ukraine on the High Anti-Corruption Court. We have PCA members present here, Mr. Robert Heinbrook-Heisen, chair of the PCAE, Mary Butler remotely, Norman Auster remotely, Gabriel Lichkart-Granskini, Jessica Lott Thompson, and John G. O'Sullivan, and also the HQCJ members, Mikhail Gabanits, Людмила Волкова, Радислав Тух, Роман Кадисюк, Надія Кабецька, Ігор Кошнір, Олексій Омельян, Андрій Пасічник, Руслан Сидорович, will just in a minute, Сергій Чумак, and Галина Шевчук. You have a right to submit recusals, submit motions, express opinions, concerns, objections upon the agreements and of the chair of the session. And do you have any recusals? No, I don't have any recusals. I recognize my rights and obligations, and Madam Shevchuk Halina is rapporteur in this case. With the decision of the Commission as of 19 September 2025, number 175, with changes, the qualification exam was assigned within this competition procedure and the stages were defined. With the decision as of 4th February 2026, the general results of the first stage of qualification exam were adopted, and according to those results of the qualification exam, Mr. Movchan has received 323.37 points and was allowed for the second stage of interviews. In 2023, Mr. Movchan has graduated from the Dnipro National University and has received full higher education in the specialty of legal science and received the qualification of a lawyer. And in 2014, Mr. Movchan defended the dissertation at the Yaroslav Mudry National University, and the thesis title was Registration Proceedings in the Activity of Executive Authorities, and he received the PhD academic degree after such defense. Professional activities of the candidate. Since 2003-2004, he has worked as a legal counsel. Since 2004-2008, he has worked in the Information Center, also as a legal counsel. Since 2008-2009, he worked as a lead legal counsel at the Information Center, LLC. Since 2009-2010, he worked as a lead specialist in the State Enforcement Service in the Dnipropetrovsk region. As of presidential decree as of March 2020, he was assigned as a judge in the district court in the city of Dnipro, and as of the presidential decree as of 29 December 2017, he was assigned as a judge at the Novokatsky district court in the city of Dnipro, and he was recognized as the one who is compliant with the functions of his position. He has experience of a judge more than 5 years. He's fluent in the state language. Mr. Movchan has submitted declaration of family ties, integrity declaration, and declaration of a person obliged to carry out functions of local governance authorities during the competition. The Commission has sent requests to the High Council of Justice, State Security Service of Ukraine, the Office of the Prosecutor General, the NACP, National Police, NABU, Ministry of Justice, and other public authorities regarding the candidate. We have received replies on our requests. That's all from my side. Thank you. Do you have anything to add to this basic information? Thank you. I have no information to add. All basic information was reflected correctly. Mr. Robert, over to you.
Thank you, Mr. Chairman. Please, Mary, the floor is yours.
Thank you. Thank you, Mr. Movchan, for your participation in this important process. First, I want to give you an opportunity for the benefit of the people watching online to explain why it is you would like to be a member of the appellate chamber of the High Anti-Corruption Court.
Дякую за запитання.
Thank
Дякую
you for
за
your question. Thank you for your interest to the activities of High Anti-Corruption Court. My motivation doesn't go from some kind of personal ambitions. No, it's a logical proceeding of my judicial career. I have been working as a judge for 15 years. I have also performed functions of an investigative judge. I've also considered in my practice criminal proceedings. And such path, it's also about to strengthen institutional capacity of the High Anti-Corruption Court, specifically its appellate chamber, from the perspective of the qualitative judges. And because all of us, we clearly understand that when the administration of justice is done properly, it also contributes to building trust to the judiciary in Ukraine. And when any of judiciary authorities is strong and capable, then it will also influence positively on the trust from the public. And so, from one side, it will contribute to institutional strengthening of the court through qualitative judges that are going to work there. Thank you.
Thank you. I first want to ask you about your use of the right to full access to the Unified Registry of Court Decisions. This is a question we posed to you during the last couple of weeks. As you know, we have information that on approximately 109 occasions between 2018 and 2025, you conducted searches of the non-public Unified Registry of Court Decisions involving the surname of a particular person and combinations of the surname and first names and middle names. And I would like you to explain why you thought that was appropriate, given your position as a judge.
Дякую за запитання. Дозвольте надати
Thank you
пояснення.
for your question. Let me give you relevant explanations. Yes, indeed. Yesterday, I sent to the PCIe my written explanations. Now, I will try to give you wider reply, if it's possible. The only comment from my side that such searches, as far as I received information and your questions, so the searches were done in different manner. So these were 3 searches during 2018, then 2019, 2020s. There were no searches at all, and the major part of searches took place from 2020 to 2025. And my explanation is the following. And as that's public interview, I will not give you the name of this person, but I know this person, and I can tell you it right now and provide it in written explanation. I know this person for more than 30 years. There were 2 reasons for such searches. So first reason is to try to prevent alleged conflict of interest that could have been raised, but luckily it didn't raise in my activities. The issue was the following. As an investigative judge, I carried out certain procedural guidance over a criminal proceeding, which is indicated by me in my written explanations to you. That criminal proceeding was related to commissioning of certain property located at a certain address. And at the beginning of that criminal proceeding, as we are closely in touch with that person, I found out that that person allegedly planned to purchase part of that residential building, specifically an apartment located on that address. And then, as an investigative judge, I receive files regarding motions on that property. And I would like to say that
так би мовити, дотримання норм суддівської етики.
And in order with compliance with the judicial ethics and professional ethics, I didn't think to inform this person that I have received assignment to consider that proceeding. So I started to communicate with pre-trial investigations. There was temporal access. There were also arrests orders issued for that property. And the situation was the following: if that person, with whom I know closely, had already purchased part of that property, and I am considering this case, it could be conflict of interest. So I asked repeatedly pre-trial investigation authorities whether they know about such owner. They gave me a reply that no, they don't know such an owner, but the transfer of ownership right was carried out by the developer under unclear, non-transparent procedure. So they suggested to receive an ownership title through court decisions, court rulings, not by my court where I work, but by some other courts which can recognize ownership right. And in order to be sure that this person who I know closely is not a party to this proceeding and has no procedural status, I carried out such searches, I looked and searched using the surname, first name, and other biographical data, because, all of us, we know that sometimes, surnames could be mentioned in different interpretations in the judiciary. And second reason which I provided, indeed, that after that criminal proceeding was closed, it was closed in 2022, the same, you were in close touch with that person. He is not a lawyer by profession, he is not an attorney, he has general economic education. So he asked me for an advice because he had legal process litigation in another court, absolutely different jurisdiction, and he was not a party to that process. And he informed me that he doesn't understand what's happening there, because to his opinion, there are certain circumstances of a case, but his attorney, professional attorney whom he hired, he started to interpret those circumstances of a case in a very strange manner, both from the perspective of the judicial practice and from legislation. So again, having no reason to disclose any information regarding any court decisions or to inform him of the process and progress of that case, I just had an interest as a judge. What was there? Taking consideration available information for me that he informed me how different judicial processes can take place and what could be potential consequences of that proceeding. So I don't hide it. I looked at that judicial practice. I analyzed such judicial practice regarding similar cases in other courts, and I advised him that it's better for him to change an attorney in this process. That's all. That's my explanations.
I have a few follow-up questions. So it's your position that in 2021 through 2023, your searches were to determine if you should disclose a conflict of interest or to recuse yourself in the matter that was pending before you. Is that right?
Sorry, partially yes. As far as I remember, and it could be confirmed, it was not 2023, it was 2022, the end of 2022, because that criminal proceeding was closed not by the court, it was the relevant ruling on the pre-trial investigation authority with agreement of the prosecutor to close this criminal proceeding. And as far as I remember, it was at the end of 2022. And so that's why specifically at that moment, there was this connection to this potential risk to have real conflict of interest, because that person could have gained procedural status in that proceeding, but that person at that moment didn't get such a status.
And did I understand you to say you asked the lawyers for the government in that case whether or not this person had a status or an interest in the proceedings? Is that right? And you didn't get a satisfactory answer, so you went to the registry. Is that right?
Саме так. Дивіться, я трохи проінформую.
I will just provide you additional information. So how actually consideration of motions of the pretrial investigations are done by investigative judge. So an investigative judge receives a certain motion with some attachments and annexes, and usually such criminal proceeding files are not provided to full extent because a prosecutor or an investigator, upon agreement with the prosecutor, they think that that's the necessary amount of information that shall be provided to an investigative judge to consider the motion at merits. And it means that based on those materials provided to me, it was unclear for me what was the participation of that person. And when I asked procedural guidance prosecutors, I received also the negative reply. But I also realized that any concerns, unofficial concerns, then will, unofficial concerns will not have any legal consequences. I will not be able to explain to that the person who I have been known for 30 years and could be there, and as an investigative judge, I actually impose arrest orders on those properties. And in that case, arrest orders were issued on those properties. I don't know who were the owners, who owned them, but I had the documents of commissioning of that building. Other investigative actions were carried out. So I have received also, as an investigative judge, so many different complaints from other owners of other apartments in the building and developer. So they didn't know each other. It was quite hard to identify the objective information. For example, I received a complaint with a surname. I can't tell you the surname right now. So during an investigative action, I asked whether you know that person with such surname as an owner. The reply was not provided to me. That was a high-profile scandal case because many people actually saw that building as a residential house, and accommodation topic and residential topics are quite, acute problem right now in Ukraine. And at that moment, I was sure that I have no biases. I act from the objective reason, and I needed to check that that person didn't have a procedural status regarding that property, even despite of the fact that earlier there was positive intention expressed by that person to purchase apartment in that building. Thank you.
Okay, and then in 2024 and 2025, you searched that same surname 37 times, according to the records we've been provided. And in this period, if I understand you, you were researching decisions of other courts affecting this person. Is that right?
Так, вони безпосередньо не впливають на цю особу.
They do not directly impact this person. They were directly related to this person. These were cases from different jurisdictions, and accordingly, that was a very weird case law. That person was involved there as a third person in some processes, and in some cases he was even the respondent under the case. And according to him, he knew about some of these processes only in very general terms. And accordingly, the issue was whether such a situation could correspond to the case law with respect to this matter. For example, whether it's possible in case...
If I may, what I'm getting at is whether you think that the use of the non-public registry by a judge on behalf of a longtime friend to help them understand the legal process is appropriate, because we are supposed to be discussing your candidacy for a position of high public trust. So I'm not interested in the particular legal issue. I'm interested in the use of the non-public registry for this purpose.
Дякую за запитання.
Thank you for your question. Thank you for explaining that. If you allow, I will answer it as follows. That I did not use this data from the register in order to pass on some information to him from this register, and he was not a party to my proceeding either. That register the study of this part of the research is publicly available by 90%. But for that, I needed surname because he did not know that information. And the search for this register was done by me, by a judge, for myself, from the perspective of analyzing case law on that matter. And I believe that if a judge is analyzing the case law, regardless of the surnames, that can be used by the judge. And right now, I'm saying frankly and openly, I, as an investigative judge, knowing that some high-profile cases are happening, for example, regarding investigative judges in Ukraine, knowing surnames that are publicly known, I'm also searching for rulings of investigative judges. I look which provisions of the procedural law they are applying and what was the destiny of the ruling of the first instance court in the Court of Appeal. Which arguments were provided by the court in case of the quashing or during the assessment of arguments of the defense party. So accordingly, I'm saying that was not related to the provision of some legal consultations or some information to him about the course of case consideration or, God forbid, about some impact on other parties of the court process. I was asked a question and I was interested and I was studying. Mr. Dmytro, and I have a request to you. Please speak slower so that we would be able to provide interpretation. Okay, thank you. Should I repeat again?
No.
Думаю, не треба, просто на майбутнє.
I think I understood. But I come back to this is seems to be a significant amount of judicial time spent doing this research in this registry for this person who is your longtime friend. He appears also to be the person who has power to use a car owned by your father. Is that correct? He has power of attorney for a car owned by your father? The same person?
This person is my classmate. He knows my father very well. Information about the power of her attorney to use the vehicle, unfortunately, I cannot either confirm or refute because that's the first time I'm hearing about that. But I assume that maybe this fact could exist because they know each other well. I cannot deny against this fact. If you can tell me at least the year, maybe I can provide some facts and I can recall them. Maybe you can tell me the year, if that's about the question about the power of attorney. And about your aspect about the time dedicated to the search, these legal proceedings involving him are still ongoing. It's a long process. And as we know, unfortunately, in Ukraine, because of the workload of courts, cases are not considered quickly, especially given that these complex cases have to pass through the first instance, Court of Appeal, then sometimes they are returned for the first instance. So right now there are no final verdicts under these cases, and I see some very interesting case law in that regard.
Okay, I want to come back to the interest of this person, your relationship to this person. This is the same person whose company paid your brother-in-law more than 249,000 hryvnia, according to the state tax records. And he also, and this is actually a question, he appears to possibly own the home in which one of your family members lives. Is that correct? Perhaps your sister?
I'm sorry, information, the questions I will start from the very end. The housing where my sister lives is not owned by this person. The owner of the housing where my sister lives is a house, as far as I know, and she and her husband are the owners of that house. Because they consulted me regarding registration of documents for this house, which they bought in 2020. Now, with respect to the money that allegedly the company of this person transferred to my brother-in-law, probably you mean the husband of my sister, because I know that the husband of my wife is engaged in commercial activities, and probably somehow they are related through this transaction, but I cannot provide this information because I have not studied that in so much depth. And I'm not so in the range of interest of their economic activities. I do not provide any consultations to them regarding their economic activities. And the dispute which I was tracing for him is about him as an individual. And with respect to their transfers, money transfers, I do not leave them as one family. We do not talk so closely in order to ask who and paid for whom because of their economic activities. So I do not know this information and I cannot explain that. But with respect to the house, I can assure you, I have this information that the house where the family of my sister lives is their joint ownership together with her husband.
We'll come to that just a little bit later. I now want to switch the topic to your status as both a judge and a licensed advocate. My understanding is that this dual status simultaneously is fairly unusual. Is that correct in your experience?
Thank you for your question. Based on my experience, it's not unusual. Why? Because as of the moment when I was obtaining this status, that was sort of a prevalent practice in Ukraine, that many persons who work in civil service obtain this status. They did not engage in attorney's activities because we have a difference between obtaining the right to engage in attorney's activities and doing that. And right now, those attorneys who become judges or prosecutors have suspended status. That's established practice. And that was my case as well. I'm saying that back then, when I was obtaining the status, that was a legitimate situation. No one disputed. There were no decisions of courts. There were no disciplinary decisions with respect to not being allowed to do that. On the contrary, there were contrary decisions of the High Council of Justice because there was a resolution of the Grand Chamber, which is mentioned by PCA members in the written questions. And yes, even after that court decision, the disciplinary practice is showing that everything that happened retrospectively complies with the legitimate situation. So that's my answer. Thank you for your question.
So am I correct that in February 2021, the Ukrainian Supreme Court held that judges should not also be licensed advocates because of the conflict in the oaths?
2021, yes, I confirm that. I do not remember about February, probably you are right. In February of 2021, there was this decision of the Grand Chamber of the Supreme Court. But again, please pay attention to those decisions of the HCJ that were adopted after February of 2021. And accordingly, I'm referring to them in my answers, that since until 2021, this situation was considered to be legitimate and there were no remarks regarding that is in 2020, 2019, 2018, 2017, and before that. So there cannot be any legislative remarks to these persons. And that is the practice.
So after the Supreme Court's decision in February 2021, did you resign your license? Did you give up your license as an advocate because you were a judge?
Дякую за запитання.
Thank you for your question. Look, it was suspended long before that decision of the Grand Chamber. As soon as I obtained the right to engage in it was suspended immediately. No actions from my side in order to exercise this right, which would implement that into the practical domain of attorney's activities like registration as an attorney and all the other things were not committed by me. So it was suspended at once as soon as I obtained this right, even long before 2021.
So by operation of law, you weren't required to take any action to give up your license. Is that your explanation?
Так, ви вірно розумієте.
Yes, you're right. I am confirming that the law did not envision and does not envision the cancellation of this right. There is no procedure for the cancellation of the right. The law states that if the person obtains such a certificate, it has to be suspended. And I would like to, again, if you're allowed, to refer to the practice that exists right now in Ukraine. For example, if now the attorney is becoming the judge, then the attorney is not canceling this right, but rather suspends this right.
Thank you. I want to now ask you a couple of questions about your income and assets. First, I want you to clarify whether my view is correct that you have been a judge for 15 years, but you own no real estate, which you've purchased with your own resources, and you have no significant declared savings, and you own no cars except a car that you purchased in 2021 for 724,500 hryvnia approximately. Is that right?
Так, я працюю сюди
Yes,
15
I work as a judge for 15 years, since 2010. I do not own any real estate. The vehicle that I own, it's relatively not cheap. That's declared. That's the vehicle that is right now declared in my asset declaration starting from 2021. With respect to savings, in the declarations, my savings are also declared, but I'm sorry, but for me, these are significant savings. Of course, I'm not a millionaire. I do not know for whom they are insignificant, but for me, they are quite significant.
So, can you explain to us, it's my understanding that you live in the house that your wife purchased. Is that right?
Я з вашого дозволу уточню, це не
If you allow, I will clarify. That's not a house, that's an apartment. The apartment was bought on mortgage. On mortgage with a bank. There was the first installment that was done using funds of my wife's family, not even my wife. And after that, these mortgage installments were paid by us as the family. Since that was 2013, 2014, I do not remember who paid how much, but I was also paying some share of these installments from the family budget. My wife was also paying some share of those installments, and now she's the title owner of this apartment. There is no other housing that I would use or own, and I'm confirming this information that that's the only housing we have.
Was your sister one of the contributors to the resources to purchase the apartment that your wife owns?
No way. My sister did not contribute anything. My sister was focused on her own family. As of that moment when I was marrying my wife, they were already dating with her husband. They had their own family issues, and my sister did not contribute. For me, as the elder brother, it would not be unacceptable from the male ethical perspective to ask my younger sister to help me financially. No, sorry, I would rather live in a rented apartment than asking my younger sister to give me money. Sorry, that's about family values. The older brother has to help the sister, not on the contrary.
Thank you. So you did disclose some information about your sister's assets, and of course there are some public records regarding those assets. I want to go back to this house that you said you understand how she purchased it. This is the 336 square foot house, and you said you understand that the family friend on whose behalf you conducted the research in the Unified Registry was not the source for the purchase of that house. Is that correct?
Він не був, я це підтверджую.
I'm confirming that he was not. What was the situation with that house? I was not the party during the agreement conclusion. I was not present. As far as I understand, that house was bought using funds which were partially given by the husband's family. His brother is engaging in business, and his family is quite wealthy. And some funds were borrowed to him by business partners of his parents. And this person whom you were asking about, sorry, wait for a second. We have also have internet connections.
Да.
It's all working. Okay, please continue. So, this person about whom you had been asking previously had no relation to the purchase of this house or any other assets that you mentioned in the questions. Based on my information, he has no relation to that. Thank you.
It's a little confusing because your brother-in-law received money from that person who's your family friend, according to public records. But you're saying it's less than the purchase price of the house, and you're saying you're not aware of any connection between that person's payments to your brother-in-law and the purchase of that house. Is that right?
Перепрошую, зовсім не так. Я не
I'm sorry,
заперечував, що вони...
not like this. No, I didn't say that they don't know each other, because he's my classmate. He visited my birthdays, where my sister with her wife were also there. I highlighted that I don't know about their business relations. I can't understand how this money was given to that person or to him, based on which business transactions or how. I don't know this information. My sister didn't inform me about this fact at all, that this person gave money. Even more to say, when I analyzed that the documents, and I also attached it to the replies to the PCIe, their funds are confirmed by the income declarations and money received from alienation of different movable and immovable properties. There were nothing indicated as something that received as a profit from any commercial activities or as a loan. And that's why, for me now, that's something new, that something was paid to my sister's husband. So if we are discussing it right now, it would be great to know at least what was it. It was loan or commercial activity, because both of them are involved into commercial activities. Maybe this was money between them, it was two private entrepreneurs within some kind of commercial activities. But I don't live live with my sister and her husband. They don't report to me how they handle those commercial activities and operations. So I don't know about their any kind of economic activities. So I know about general things. Of course, it's normal. We are close persons, but those details of such transactions and sums of these transactions are unknown to me. That's why that's the same as they don't know about my remuneration and about the cases under my consideration and where I go each day. That's not our circle of interest that we share with each other.
Okay, and one final question. We have information that with regard to your wife's income, that she has received maternity benefits since 2019, and that's the only reported source of her income. Is that correct?
Yes and no. Sorry, maybe I'm mistaken. I heard 2012. No, 2019. We have a
2019.
child born 2019.
Якщо є там дитина з 12-го, то це не моя, я перепрошую.
If 2012, sorry, that's not mine. I don't know about it anything. No.
No. 2019. Okay. Is that right?
Sorry, that was me. Misheard you.
No problem. And what I want to ask you about is the fact that there are Instagram posts of your wife with information that suggests that during 2024 and 2025 that she provided 200 hours of individual consultations as a psychologist, and that she worked in a private school and a kindergarten. And so I want to ask you whether she obtained income from that work, which should be disclosed.
Дякую. Якщо
you.
вона отримувала дохід, я
If she received any income, I think that I, as a husband, would have known. As far as I know, since 2024, my wife, she has been studying as a psychologist. She's enrolled in the higher education facility, and relevant certificates I have attached with my replies, which I sent to the email address of the PCIe. So during this studying process, at this education facility, I think it's for the purpose of accreditation, if I'm not mistaken how it's called. So the requirement of this accreditation was that in order for a person to get relevant certification, this person shall provide a certain number of consultation hours and carry out certain hours of practical lessons. So my wife doesn't work. She doesn't have any labor relations with such facilities. That's only in terms of within her studying internship. That's our child attends this preschool facility. So she comes there pro bono, and you can check your bank records. She has not received any payments at all. All those consultations have been provided and are going to be provided till the end of her studying process. She's going to study a year or two. So that's same as lawyers. You know, lawyers, legal students shall come to a court, observe, watch, carry out some tasks of the head of the apparatus of the court. The same is here. Those students come to different education facilities, studios, and workshops and carry out different things and report them, what they have done. So, of course, during such learning process, they provide different kind of consultations as students or postgraduate students. But that's not a paid service provided because she's still studying, and that's why any labor contracts without confirmation of the qualification level at this sector is just impossible. In order to conclude any kind of labor agreement with any education facility, you need to prove that you have a higher education on this track and you have a right to carry out relevant activities. So what's happening right now, that's such kind of internship, so to say, is that a requirement of your higher education facility. In order to be enrolled into a higher course and to receive the next academic degree, she he needs to do such number of consultation hours and practical tasks. It should be corroborated. And in order to corroborate it, it could be photos of social media. I don't have access to her social media Instagram post, but I'm sure that it's photos of process where my wife communicates with children. It's not a learning process. It's communicating with children from a person who is studying for a psychologist. If you have any questions, I'm ready to answer. And sorry, the curriculum for this specialty, I have also shared with the PCIe in my letter. The link to this curriculum, you can follow the link and see what the requirements are for getting this degree. That's the requirement of education facility rather than we making up something.
Thank you. I have no further questions.
Дякую вам за ці запитання.
Thank you for these questions.
Any of my colleagues, a further question? Yeah, I had one question for you because I was a bit amazed that you work as a judge since 2010, I believe. That's correct, huh?
Так точно, я це
Yeah,
підтверджую з
yeah,
2010
you're right, since 2010, February 2010.
And you obtained your lawyer's license in 2020. Is that correct? 2021?
Ні, до 21-го року.
No, before 2021, a little bit wrong. And if I may, I will explain the situation in order for you to understand how they are related.
В Україні на той
In
час,
Ukraine, at that moment, when I became a judge, as many of my colleagues, we were appointed first time for 5 years. So first tenure period was 5 years. And in 2015, certain events took place in Ukraine, and I was left without judicial powers for 3 years. And that's why, as my future was unknown to anyone, and I'm open with you. So each day at TV, it was announced each day on news and TV that we will dismiss and fire all judges. As I was in the status, in the condition of legal uncertainty, I was without any power authorities as a judge. I didn't have right to do anything, but I needed to professionally develop, to think about my professional future. I started to apply to the National School of Judges, and I started to this process of receiving the status of an attorney. That's not 5 years, that's not a short period of time. A major part of that studying, of that internship, took place when I didn't have judicial powers. But of course, when I renewed my status of judge, I just terminated that. I just completed the studying process for the attorney because major part had already been done.
But you still had the license when you were a judge.
Вона зараз не діюча, вона
So for
зупинена
now,
повністю.
this license is fully suspended. It's not active license. In order to have an active license, I need to take a legal measure. I need to quit my job, then to take measures to renew this license. Now I have no right to carry out such activities. So if I come right now into any process presenting myself as an attorney, according to official data from the state, I have no right to do it. Not because I'm a judge, but because at the bar database, my activities are not active, but they are suspended.
Yes, but what I find strange is I'm an attorney, and I act for clients, and I represent their interests, and I expect a judge to be independent and not representing anybody, and not showing to the outside world that he may be for hire or something, or he maybe have a license to practice. Would you agree with me or not agree with me that having a license as a lawyer is something that is conflicting with the job as a lawyer, because the outside world may think that even though you are a judge, you still may be for hire?
Я дозволю себе з вами не погодитися.
I will allow myself not to agree with you. Look, even now, for this competition of HCC judges, we have a lot of applications from attorneys, and those attorneys also can suspend their licenses and start working as judges. So working at courts, they can have suspended licenses. At many courts, we have judges with previous background of attorneys whose all those judges have their licenses suspended. And in no case, they have this issue of a conflict of interest, because in this case, they cannot harm me because they do not have this right. And I don't represent any bar organization or self-governing organization. That's why then the question, how I can be hired, whom I will be able to present. That's some kind of, certain practice in our country. Again, I would like to highlight it. Even if in this competition, if we have applications of other attorneys who have applied for vacant positions of judges, and if they succeed, they will become judges. They will suspend their attorneys' licenses. They will be judges with suspended licenses of attorneys. It doesn't mean that they will have any conflict of interest. So, sorry again, but I will allow myself not to agree with your opinion that the effect of suspended license causes the conflict of interest. The same is about academic specialists, scholars who will become judges. There could be conflict of interest because their parties to their future processes or proceedings could be their former academic supervisors or people who they know from educational facilities. The conflict of interest means when we have personal interest, or for external observer to have this notions that I could have potential interest, but I don't have such interest. And about hiring myself as an attorney, it can't be even an issue, because speaking about a formal procedure for attorney.
That's not what I said. What I said is that third parties looking at you as a judge, they try to find you, and they find a judge with your name, and they also find someone who has the same name with a license to practice as a lawyer. The question is whether the outside world, who look at you as a judge, they consider this great. Yes? I don't say that you have a conflict of interest. I say, don't you think this is conflicting in your job as a judge? And the answer that you gave is no. And maybe I'm completely wrong that this is normal in Ukraine, but yeah. Okay. Yes, Jessica.
Я можу ремарку сказати, навіть
Sorry, may I add comments? Now, I will even go into the list of judges of Supreme Court, and if I check how many attorneys of them, and there are judges who were attorneys and who were appointed according to the results of competition. And as far as I know, no external observer has no doubt that the acting attorney who became a judge had a conflict of interest. Thank you so much for your question. It was very interesting.
If I might comment on that, don't want to be in a discussion. I don't think that answering the question can be done by referring to someone else. What I asked is what your opinion was about this. But don't let's have the discussion. I think the HQCJ will know much better how this works in Ukraine.
Thank you, and thank you for being here today to answer our questions. I'll ask you some questions in relation to judicial ethics and mindset. Ukraine is a member of the European Convention on Human Rights since 1997. Is this correct?
Yes, yeah, it
Are you
is.
aware of the provisions related to gender in the Ukrainian constitution?
Питань гендеру, я перепрошую.
Gender issues.
Gender equality, the equality between men and women.
Так, знаю таке питання.
Yeah, I know this issue.
We have heard some of your thoughts today regarding family values in relation to your sister and to your wife, to their earning of income, and to your thoughts about family values. So I would invite you to communicate your thoughts also about your relationships in the workplace as a judge and throughout your career with women. As a member of the High Anti-Corruption Court, you will work regularly with women on the basis of equality and consistently with the European Convention of Human Rights. Can you provide me some examples of when you have worked with women as co-judges, as lawyers in your courtroom? Please provide me some clarity about your perspectives and opinions about the strength of women in the workplace.
Дякую, я з вашого дозволу повернусь.
Thank you. I will turn to you, if I may. So regarding my comment regarding the sister, it was not the issue of gender inequality, or they think that my sister is a woman, she is weaker than I. I think she's just my sister. And when I was older in childhood, I always protected her. I protect her as a young sister. So from the perspective of protector, that's my psychological, attitude to her. Regarding women, so in the court, I work with the reception room. So my secretary is a woman, assistant is woman, so my colleague is a woman, her assistant secretary woman, another judge woman, her secretary assistant woman, the head of the apparatus of the court is woman. Before last year, the head of the appellate court of the Dnipropetrovsk region, it was Derkach Natalia Mikhailevna, woman. With all of them, I have wonderful relations, and I think that we work equally on equal basis. And there were no complaints from my side, and I had received no complaints against me regarding any unethical behavior against women. So there are no complaints like this. We work with all of them very fruitful atmosphere. We treat each other as peer-to-peer, and I don't differentiate anything at my work. So if she's a woman, what does it mean? Does it mean that she can't work? No. Together with them, we consider different cases. I see how they work. Sometimes, in a major part of cases, they actually work even harder than I do. So from the perspective of professionalism and working ethics in terms of gender policy, I'm as a man, there are fewer men in our court, but it doesn't become an obstacle for me or them to have fruitful work. So we have fruitful working relations, always maintaining this equality and professionalism independently on the gender. We are professional judges. We are professionals on our occupation. So the most important for us is the result of the case rather than such things. So there is no problem with it.
Thank you for the answer.
Any further questions, colleagues? Back to you, Mr. Chairman.
Дякую.
Thank you. Dear colleagues. A few questions to you. According to the data of the Information and Analytical Support of the National Police of Ukraine, you are the owner of 9 weaponry pieces, including you have 1 gun of the 9mm caliber, 9mm size. What was the reason? Is it an open interview with broadcasting? Yes, of course. Some things I just can't share with the public, because that's the weapon which was received from the main reconnaissance directorate of Ukraine. So in order to carry out certain actions, I cannot tell you what specific actions, because when such licenses are given to a person, NDA agreement is also signed. Okay, thank you. And as far as I mentioned, you are the owner also of 9 other small arms. Yes, it's mine own. It was not given to me. This is not some kind of historical thing. No, this is available on the market. So it doesn't require to be. It's not required to be declared. Each piece costs $700, $800. So in the system, there shall be prices for all the pieces of weaponry that I own, of all the small arms. So let's go back to the issue of your attorney's license, which you have received in 2020. So we have clarified all the issues. So please tell us more about motivation, but be concise. So your motivation, has it changed would you be a judge? Would you like to be a judge, or do you have any still intentions to become an attorney?
I'm honest in answering this. Look, that is the second competition to the High Anti-Corruption Court in which I'm taking part. Even regardless of the fact that the first competition had negative results for all of us due to some specific reasons last year, it did not change my mind, and so I've applied for the second competition. In my opinion, that shows my sufficient motivation to be a judge of Hague. So the desire to work as of today as attorney, no, I do not have it. If I had it, then I would just have resigned. But no, instead, I'm dedicating my time, for nerves and resources for the second time in a row to demonstrate my willingness to work as the judge of the Hague. Okay, understood. Thank you. So your motivation remains the same. Yes, my motivation is persistent. Okay. What are your strengths that will help you if you gain this position of the judge of the High Anti-Corruption Court? I have many of them. If we are not talking about the main ones, yes, several briefly. That principled position while resolving professional issues, that is thoroughness in resolving professional issues. For example, with respect to my friends, I think I've already demonstrated that I'm studying everything thoroughly and not superficially. That's my legal experience in the judiciary sphere, ability to analyze and draft court decisions and to thoroughly check them. That's objectivity during case consideration. There are no complaints against me, no disciplinary complaints against me. None have even been initiated regarding that. Okay, thank you. Maybe colleagues have some other questions. Mr. Mikhailo, please. I have one question to you. Tell us, please, what is your understanding of the conflict of interest? Now we are talking about the real or potential one. Now we are talking about the general notion of the conflict of interest. Conflict of interest is the following. These are some circumstances, activity or lack of activity, which has to cause among external observers some doubt that as a result of my work in the conflict of interest situation that I or affiliated persons or third persons will get some benefits or advantages. And accordingly, while acting in the context of this conflict of interest, I'm not impartial and fair during the court proceedings, but being governed by some interests. Can you disclose the essence of this notion with a reference to the definition that we have in the law on corruption prevention? Or do you believe that this is the regulatory definition? As an academic who prepared the dissertation, I'm always saying that there is the academic, broad, and regulatory definition. Okay, let's not talk about academic interpretations. I understand. Yes, I believe that this is a regulatory definition. Okay, so existence of a reasonable doubt is also a sign of the conflict of interest in my opinion. If there is a reasonable doubt, you have just answered that. Look, if we are talking about now the reasonable doubt, the very existence of reasonable doubt is not a sign of the conflict of interest per se, but it precedes the resolution of this issue procedurally. In my practice, I will try to lead you to the definition set out by the law. The law sets out that the conflict of interest is the existence of a private interest in the sphere of performance of public duties of the person that is impacting or can impact performance of some duties. So the mandatory sign of the conflict of interest is the existence of a private interest. That is the definition that is close to the one that is set out by the law on corruption prevention. In continuation of this topic, what is the basis of your private interest in relations with this person about whom you were collecting information in the register of court decisions? There is no private interest at all there from the perspective of the anti-corruption legislation. Okay, thank you. I've understood the answer. So the conflict of interest that you mentioned while answering the question of the PCA members in the understanding of the law on corruption prevention could not be stated there. We could talk about existence of the conflict of interest because the question was about the existence of the conflict of interest if he had become a participant of the criminal proceeding and obtained the status. So what are the signs of the conflict of interest in this case if he became became a participant of this criminal proceeding. That is my close person. I'm sorry, I have subjective feelings towards him. And it's not clear how the person who is a close person entering the process, how objective that decision would be. Okay, private interest is also the notion that is defined by regulations. And the law on corruption prevention envisions grounds for the emergence of private interest. Please explain with references to the law, based on what would your private interest be based in relations with this person during fulfillment of your judicial duty? Do you understand the question correctly? Sorry. What would be the basis of my private interest if this person became the party to the criminal proceeding? Given the nature of your relations with this person, what would be the basis of the private interest? Okay, I will answer as follows. The criminal procedural legislation and other legislation single out that one of the conditions for recusal or self-recusal of a judge is the fact that their close relatives, close persons take part in the proceedings. And that was something that I would be governed by, because this person whom I know for over 30 years is my close person. Okay, thank you. So we are not talking about the conflict of interest according to the law on corruption prevention. We are talking about a slightly different phenomenon, which is not a conflict of interest according to you. Okay, and my final question. If you have such close relationships with this person, you know him for over 30 years, why could you ask directly this person whether this person was a party to this proceeding? And to clarify this information from this person directly, that you were trying to find through such difficult ways. I have partially explained, and I will explain again now. That is a pre-trial investigation, and there is the secrecy of the pre-trial investigation. If I started talking to this person, then due to the nature of our relations, I would have to tell him some things that I cannot tell him as an investigative judge, with references to materials of pre-trial investigations that are prohibited for disclosure. Which apartments would be arrested, which investigative actions are planned. So basically, I would have been informing the person about the plans of the pre-trial investigation body. I'm not asking you about that, sorry. I'm asking you not about that. Okay. Given your life and professional experience, experience of communication in the society, experience of your social ties, I can assume that this is not the only person in your life with whom you have prolonged friendly relations. Yes, of course. What about the similar algorithm of information search regarding other your acquaintances? Are you using the same algorithm when considering criminal proceedings? That's the only instance in my practice when I had information that my close person had a connection to that criminal proceeding where I was an investigative judge. I do not know about other persons. So accordingly, with respect to other persons, and the members of the PCA can confirm that I was searching for information only about one person. All of my other close persons were not featured in proceedings where I was the investigative judge, and that's why I was not looking for information about them. Okay, thank you for your question. Colleagues, do we have any other questions? Good afternoon, Duch Yaroslav. Tell me, please, I have a question about your practical assignment. Do you remember the verdict of the first instance that you prepared during the previous stage of the competition? No, in this competition. During the previous stage. Partially, yes, I remember that. What's 366, Rim 2? Yes, so far as I remember, that was a member of the village council, yes. Unfortunately, I did not see your analysis of the position of the defense party. Can you recall what was the cause for that? I will explain as follows. In order to substantially analyze the position of the defense party, my opinion as a professional working with different categories of cases is that I need to have the entire case in front of me. Unfortunately, the task was formulated in such a way that the position of the defense party mentioned in the plot of the assignment was very narrow and short. And basically, 2 paragraphs.
Не було як.
No, there was nothing to analyze that. Basically, that would be philosophy. So I proceeded based on that fact. Okay, I understand your answer. I am fine with it. My question is that the position of the defense party was that it was necessary to apply not the current version of the law, but the previous one. And without taking it into account, you applied the sanction of the article that was not in effect as of the moment when the criminal offense was committed. That's the reason of my question, that you applied 6,000 untaxed minimums, but the maximum penalty was in the form of 4,000 untaxed minimums in the previous version. Tell me, please, did you have to apply Article 5 of the Criminal Code in this case, and if yes, and with what? Unfortunately, I do not remember the amount of the penalty that I used, but I used the current version. We had access to the current versions of the legislative framework, and in view of the time given for this practical assignment, I used the version that was current as of the moment of drafting the verdict. Okay, thank you. Colleagues, do you have any other questions? Yes, please. We received information from civil society organization, Transparency International Ukraine. We received some questions, and they expressed concerns regarding some facts from your activities. Basically, all of these questions that have been mentioned about vehicles, purchase of property have already been discussed. But we have not discussed one issue. Maybe you can answer that. The civil society organization is saying that September 23rd of 2019, the candidate was selected as a delegate for the 7th meeting of judges from the Novokatsky District Court of Dnipro, and the Council of Judges was supposed to choose 3 members of the selection commission to assess candidates for the position of members of the HCJ. And it's candidates from the delegates that refused to consider the issue of delegation to members of the selection commission. There were in selection of commissions members who were supposed to select HQCJ members was blocked. I will explain. I remember that, and I will explain it as follows. Indeed, I was elected as a member of the Council of Judges, and back then I was a member of the Council of Judges. I would like to categorically deny against someone blocking something. No, the matter was the following. The law sets out the specific procedures, stages, that at first there should be an announcement, then candidates should be selected. Some civil society organizations suggested in the social media to violate this procedure, to ignore stage 1 and to move on to stage 2 at once. My position as a member of the Council of Judges, as a lawyer, as a judge, was that if the current legislation envisions some stages, these stages has to be followed. Moreover, a week after that, as far as I remember, the first stage was completed. The Council of Judges did everything, and all of these HR issues were resolved on time, thanks to the Council of Judges of Ukraine. Okay, thank you. And my last question is the following. Since you are taking part in the competition for the Court of Appeal of Dnipropetrovsk region, what are your priorities? Briefly, because you're also taking part in our competitions and in the next one that we are going to have. So what is your priority? What is your vision? My vision about priorities is that I'm here now. And even if this competition for the Court of Appeal would be fought by me back then, even if it had been the first before they had, I would have withdrawn my candidacy from that competition to stay here, regardless of the fact that I might not pass the interview. So my priority is the High Anti-Corruption Court. Okay, thank you. Dear members of the PCIE, maybe you have some questions to the candidate.
Norman and Mary, do you have any follow-up questions? No? No, thank you, Mr. Chairman.
Добре, дякую, пане Дмитро. Вам надається
Okay, thank you, Mr. Dmytro. Now you have a chance to address the members of the HQCJ and PCIE up to 1 minute. Maybe you would like to provide some additional information. I do not have any additional information to provide. I think that I've answered all the questions. I would like to express my gratitude to dear members of the PCIe and to members of the HQCJ for being very thorough in these selection procedures, that you are studying our biographies so thoroughly. And of course, there are some controversial questions to which candidates should answer honestly. Thank you so much for the invitation. Thank you for very interesting questions asked here, and I wish everyone a good day and a peaceful sky. Thank you. So now I'm announcing the interview over. Thank you for your participation. Goodbye. Colleagues,